Good afternoon. I think we will begin. Good afternoon and welcome everyone. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to welcome you to our annual Nies Lecture in Intellectual Property. We are delighted that you are here. I want to begin by recalling the person in whose memory this lecture series stands. The law school created this lecture in 1998 to honor the late Helen Wilson Nies, who had served as a judge of the United States Court of Appeals for the Federal Circuit, including a term as its chief judge. We did so at the suggestion of one of our faculty, who secured the enthusiastic assent of the Nies family. Judge Nies is widely remembered still today within the intellectual property bar as a very generous individual and a hardworking, serious, and modest judge. It has been a great privilege for us to make this lecture a constant of our intellectual property program, even as, under the leadership of Professors Bruce Boyden and Kaylee Murray, we have expanded that program in recent years. Today's lecturer has deep experience with and an important perspective on intellectual property law. Brad Smith is the longtime Chief Legal Officer of Microsoft Corporation and, more recently, became its president as well. In these various capacities, Mr. Smith leads Microsoft's corporate, external, and legal affairs. His team of more than 1,300 professionals working across the world is responsible for the company's legal work, its intellectual property portfolio, patent licensing business, corporate philanthropy, government affairs, public policy, corporate governance, and social responsibility work. For someone merely to help lead a company of Microsoft's size, scope, and importance would provide an significant and important and invaluable perspective for us. But Brad Smith's influence extends into public policy more generally. For example, he is a strong advocate of diversity in the workforce, arguing that his company, the legal profession, and the country more generally cannot fully succeed without it. He is articulate on the importance of the global marketplace. He has spoken to the balance or tension between national security and individual privacy. These wide-ranging interests and abilities prompted the National Law Journal to name Mr. Smith in 2013 one of the 100 most influential lawyers in the United States, and more recently, the New York Times to characterize him as a de facto ambassador for the tech industry. And if you consider what ambassadors do, it is not simply to engender good relations, but artfully to communicate hard truths and to try to reconcile divergent interests. To all this, Mr. Smith brings not only a career of experience, including private practice in Washington, D.C., but also a certain Midwestern sensibility. Before he decamped for Princeton University and Columbia Law School, our state was home for the young Mr. Smith, who grew up in Appleton, Wisconsin. Won't you please join me in welcoming, for this year's Nies Lecture, Brad Smith.
Well, thank you so much. It's a real pleasure for me and my colleagues from Microsoft to be here in Milwaukee and at Marquette today. And I do want to talk about intellectual property and more. I really want to sort of address the wide range of legal and policy issues that are facing not just the world, but I will say Wisconsin and Milwaukee, and even all of you who study, who write, and who come to events like this at Marquette. I have to say it's an amazing opportunity just to spend the day with you here and see this beautiful building and be exposed to all of the fascinating work that is going on. It's a good thing because I think the world needs this kind of building and this kind of faculty and university more than ever before. Before I turn to the world of law and intellectual property and public policy writ large, I want to talk a little bit about context. Because as we look at the world, we really believe that we're on the dawn of a new industrial revolution. a fourth industrial revolution, to use the phrase of the World Economic Forum earlier this year. Now, when you think about it, of course, if we're about to start the fourth industrial revolution, the first thing that tells you is that there have already been three revolutions before. And it's interesting to pause and reflect on what we can learn from that. The first industrial revolution started in the late 1700s. It involved the steam engine and locomotion, and before it had run its course, it had permanently changed human imagination. Because for the first time, people could build a machine that would travel faster than a horse, that which had defined the fastest speed at which humanity could move, literally, for millennia. In many ways, the first industrial revolution was exceeded in importance by the second. It was an industrial revolution that began in the 1870s, and by September of 1882, it brought the first hydroelectric power plant to the United States in, I'm proud to say, my hometown, Appleton, Wisconsin. It brought other sort of miracles as well. Mr. Harley and Mr. Davidson, by 1903, were just down the street working on the first motorcycle. But if you want to get a glimpse, not only of the importance of the second industrial revolution, but perhaps of our future, I think you can see it in two photographs. The first photograph was taken in New York on Broadway in 1905. And if you study this photograph carefully, you will see trolleys and horses and not a single automobile. Now, in this next photograph, you will see at precisely the same location, 20 years later, trolleys and automobiles and not a single horse. It took 2 decades for all of the horses in New York City to be replaced by cars. And of course, what that meant was sweeping changes for the economy. In 1905, 25% of all agricultural produce in the United States was used to feed horses. But 20 years later, the population of horses had fallen from 6.5 million to 1.5 million. All of the jobs that existed in New York City to feed horses, to care for horses, to drive horses, to clean up after horses had disappeared. In fact, by 1925, there was an agricultural recession here in Wisconsin and across the Midwest because it turned out that those horses ate a lot of food. Each horse that worked in a city consumed the equivalent of 4 acres of produce. So you see the way these things reshape the economy and society. Something that we saw again in the third industrial revolution, a revolution that we at Microsoft participated in. A revolution that changed how people create, the way they connect, the way they learn from each other. But in many respects, I believe that the single most important contribution of the third industrial revolution is the foundation it has laid for the fourth industrial revolution that is starting to unfold. It's an industrial revolution that is largely founded on 3 broad sets of technological change. The first is in the physical world. As we see advances in robotics and new materials and 3D printing that will change manufacturing in autonomous vehicles. If that were the only change coming, it would be of huge importance. But there are other things too. We're seeing changes in the world of biology, founded on genomics and genetic engineering that will change human health and agriculture and the care and feeding of livestock. And finally, we're seeing changes in the world of digital technology, from the Internet of Things to blockchain and a variety of new disruptive business models. Now, what's interesting when you look at these industrial revolutions is that they're all fundamentally founded by 1 or 2 critical enabling technologies, technologies that drive everything else. It was the steam engine for the first industrial revolution. It was electricity and then the combustion engine for the second industrial revolution. It was the microprocessor for the third. And when we look at every single technology on this slide, when we think about every advance in the fourth industrial revolution, they all depend on one thing. It's the cloud. The ability to make use of massive computing power in data centers distributed around the country and indeed around the world. Which is why, as we look ahead to the future of law, to the future of public policy, it is important to think about the broader issues we're going to have to address. That's what we've been trying to think about as a company as we think about what we've called a cloud for global good. As we've thought about these changes that are coming, you won't be surprised to hear somebody from Microsoft say, we are excited about the future. There are a lot of new benefits that will be created. But we sometimes part company with others in the industry when we believe and say that we need to acknowledge explicitly that with opportunity come challenges. There will be new problems we'll need to address as well. We will need to act with a sense of shared responsibility. As we think about the role of the private sector and our responsibility as technology providers, as we think about the role of the nonprofit community, as we think about the role of government at the local, state, national, or really global level. The only way we're going to be effective in addressing these opportunities and challenges, in our view, is to have a clear eye towards some common goals. And for us, the goals are threefold. We need to build a cloud that is trusted, that is responsible, and is inclusive. And every one of these areas involves new challenges and new changes for important aspects of the law, including intellectual property. But before I get to intellectual property, let me first take the theme around trust. All of our data is moving to the cloud. As we've thought about what we need to do to ensure a trusted cloud, we believe it's important to be clear and pursue laws that ensure that there is security for our information, protection for our privacy, transparency so we know how our information is being used, and compliance so that those of us who are in the business of running data centers, providing cloud services, and serving as custodians of information are managing your information so that it is compliant with the law. But in many ways, all of these things often boil down to one thing. I'm so often struck when I meet with people around the world, it almost doesn't matter what culture or country. People basically want the same thing. They basically want one thing. They want the confidence that the traditional protection that they have had for their information stored on paper will persist when their information moves to the cloud. Not more protection, not less protection, but a comparable level of confidence. Now, as we've had to work through this as a company and as an industry, we've really had to think about what this means. What does it mean for our rights as Americans in this law, under the law in this country, for people around the world? And as a result, we've concluded that there are certain rights that are important, that are worth standing up and defending, which we have taken the unusual position of doing by actually filing not one, but 4 lawsuits against our own government, the United States government, over the last 3 years. The first case we brought was in 2013 under the First Amendment of the Constitution, where we argued that the American public had a right to know broadly about the kind of national security orders and letters that those of us in the tech sector were receiving. A case that we were able to settle in 2014 in a manner that now enables us to publish information every 6 months so the public knows how many orders we're getting. We concluded that enterprises have a right to know when the government is accessing their company's email so they can defend themselves. If you think about it, companies for centuries, basically, have had paper. They've had those papers on their own premises. Throughout our lives, they've been stored in filing cabinets. And if the government wanted to access their paper, they had to serve a subpoena or warrant on the company. And the company could decide whether to turn them over or go to court. And yet we found that the government was coming to us and asking us on occasion for enterprise email instead of going to our customers. And we put in our contracts an obligation that we would stand up and we would go to court if needed to defend enterprises' right to defend themselves. We brought a case to do that, and as we progressed, the FBI withdrew its subpoena and went to the customer instead. We believe that there is a right of all Americans reasonably to know when the government is accessing their email. Not always. I mean, there are times when notifying someone in a criminal investigation, in a public safety related case, would put at risk public safety itself or the potential destruction of evidence. But when you think about it, we have lived in a world basically forever where eventually even military secrets were declassified after some period of time. And yet we found that over 18 months, we had received over 2,000 government warrants that had a gag order that literally would last forever, so that people would never know that the government had obtained their email. So we're in court now challenging that. And in some ways, in my view, one of the most interesting and important cases involves the rights of citizens worldwide to be protected by their own laws. When you think about it, we would argue that the world depends on having peaceful relations where governments respect each other's borders, each other's sovereignty, and each other's laws. And of course, we also live in a world where increasingly data needs to move across borders. Well, how do we reconcile all of this? We found ourselves facing this issue squarely when there was a case that started on this rather small island, off another island off the coast of Europe called Ireland. And when we found ourselves looking at a US search warrant seeking to pull email out of this data center in Dublin. Now, because we store email in locations that are closest to our customers, we have Europeans, in some cases who have never been to the United States, suddenly, in this case, in a narcotics case, facing a warrant with the US government seeking their email. That's when we went to court and argued that search warrants actually don't reach beyond the water's edge under the Electronic Communications and Privacy Act. It was a case that we pursued starting in 2013. It was a case we lost before a magistrate, lost before a district judge, but built a large coalition of amicus supporters that included the government of Ireland itself, American and European businesses, privacy groups, business groups. And so it was a big day for us this past summer when the Second Circuit Court of Appeals ruled unanimously in our favor. They held that, in fact, search warrants did not reach beyond the United States. It was, as Fortune magazine said, a good week for Microsoft, but more importantly, it was, in our view, a great week for the cloud. Now, we also recognize that these kinds of things involve more than lawsuits. They involve more than posing problems. One has to pursue solutions. And we therefore took our case not just to court, but to the White House and to Congress. We took our case to Congress earlier this year. We took our case to a hearing before the House Judiciary Committee. And for all of us who think about modern day law and modern day technology, but in fact some legal principles that arguably have lasted for centuries and are even timeless, there was a fascinating exchange before the House Judiciary Committee this past spring. I was one witness that testified, but the most interesting 2 minutes of the hearing, in my mind, that sort of encapsulated so many questions about technology and the law, were summarized in an exchange with the Department of Justice's witness, an exchange that you see here.
The country of Ireland decides that, in fact, you committed a crime, and they want yourself back there. Should they be able to simply unilaterally go to an Irish court, issue a warrant, and come get you?
So if the country of Ireland did an extradition request for me?
No, they want to come haul your ass in.
I would oppose that.
Okay, so in the tangible world, that's an example where we have absolutely no authority whatsoever to take a person, by the way, U.S. or otherwise, from another sovereign country. Right, but let's just look at the intangible world, the piece of paper reduced to a PDF, because that's really what we're talking about. We're talking about something that could be tangible fairly quickly, but happens to be in electronic format, correct? Okay, and you want us to assume somehow, as to U.S. corporations, Microsoft, Apple, whoever it happens to be that, in my opinion, is being bullied by the Justice Department today in some ways, you want us to believe that you should throw out all the history of extradition, all the history of you don't get it, you get to ask another country for it, and you want to have an absolute right to demand it and get it if a U.S. court says it and you have jurisdiction over the entity who could control the bringing of it back electronically to you. Is that correct?
Well, as the Court of Appeals concluded, as we argued, that is absolutely correct. That is what the Justice Department argued. And that's what the court concluded was not permitted by U.S. law. But what we ultimately need to recognize, we believe, is that we need a new generation of international law if we're going to solve these problems in ways that let law enforcement do its job, work across borders, but do so in conformity with domestic and international privacy principles. That's why we were so pleased earlier this year when the United Kingdom and the United States signed a new bilateral agreement enabling law enforcement to work in a new manner. And it's why we're committed to a future where there are more multilateral agreements that enable the world and the use of data to function lawfully and more smoothly. All of these are just some of the issues that we'll have to address if we're going to build a future for technology where people feel they can trust the products they use. Now that takes us to the second area. What does it mean to build a cloud that is responsible? Well, in fact, it's a number of things. The first is we need to advance sustainability. Our data centers already consume more electricity than the state of North Dakota. And therefore, we, as a company, as our competitors, all need to make our data centers more efficient and perhaps most especially more focused on the use of renewable energy. That's why we announced earlier this year that today we get 44% of our electricity from renewable sources. We'll reach 50% by 2018. We'll reach 60% by early in the next decade, and we'll need to keep getting better and better and better. But that's just one area where the sense of responsibility is worthy of more thought. Another is the future of artificial intelligence, the law that does not yet exist for artificial intelligence. When I first worked as a lawyer in Europe in the 1990s, there was no such thing as a privacy lawyer. There was barely such a thing as privacy law. 20 years from now, there will be a course here at Marquette called Artificial Intelligence Law. It'll probably come a lot sooner than that. There will be AI lawyers as we think about the responsibilities of machines and the companies and people that invent them and how they are deployed with a view to societal values. We also need in the intellectual property space a patent system that will drive the kinds of broad-based innovations that are really needed to bring all of these cloud technologies to life. One of the things that is evident to us is that this is not just about a small number of companies whose names people recognize on the West Coast of the United States, the Microsofts, Apples, Facebooks, and Googles of the world. In fact, every company is and will become a digital company. Kohl's will be a digital retailer. Northwestern Mutual Life will be a digital insurance company. Digital technology is making its way and is transforming every one of these businesses. In fact, it should cause us to reflect on the critical role that intellectual property plays here in the United States. It's responsible for over 40 million jobs and $5 trillion of economic activity. Among the 50 states, Wisconsin ranks as number 14 in the number of patents held. And you see the wide array of businesses that have widely varying numbers of utility patents. And if you were to look at design patents, you would see a company like Harley-Davidson quickly move close to the top. It's fascinating when you look at the innovation awards going to new businesses here in Wisconsin, and you see the way they touch everything from agriculture to human health to transportation to the water supply and infrastructure. In fact, they show that every company is becoming a digital company. What we think about, what we recognize when we look to the cloud is the mixture of technologies on which people will need to rely. There's open source software playing a larger role than ever. There's proprietary software as well. People need to bring these together and create new solutions that are based on multiple technology building blocks. We live in a country that has undergone over the last decade a variety of almost sea changes when it comes to the view that the Congress and the courts have taken to the patent system in particular. We've gone from a system where there were concerns that the patents were too easy to get for innovations and inventions that did not merit it, to increasingly people having some inventions and the fear that they won't be able to protect them. What we really need, in our view, is a more stable and balanced long-term patent approach. But more than that, we think it's worth recognizing that this isn't just about courts or Congress or the law. So much of what will be needed from a patent perspective to encourage IP-based innovation will in fact be the action of companies to license patents more broadly in ways that will help new technologies take off. You see a glimpse of this in something that I never thought I would be up in a law school showing, a marketing video built by lawyers in the intellectual property business at Microsoft. So take a minute and just think about what that means when you see this.
The power of connected car begins with a vision. To bring our learnings from inside the office to transform the driving experience. To make what we do in our cars and how we drive something new, dynamic, and exciting. Here at Microsoft, we're not building cars. We're creating the technology to make your car better. We've been pioneering the technologies that changed how we drive, like remote sensors, navigation, mobile and entertainment features, and voice recognition. And we developed the operating systems and connectivity that help identify problems before they happen and connect people to roadside assistance in an emergency, making driving safer and our cars more secure. And since 1995, we've been collaborating with the world's most innovative car companies to create the technology that empowers people to do more in their cars. Today, all of that is about to get even better. Driving can be so much more than taking you from point A to point B, so your life doesn't stop when you get in the car. The future of connected car is being built on the technologies that will make driving personalized, predictive, and proactive. The cars of tomorrow will soon serve as rich computing environments. They will do everything from communicate diagnostic status and preemptive maintenance to anticipating your next move in your schedule. At Microsoft, we invest more than $11 billion in R&D to build the next generation of innovative technologies to get you there. We are on the cusp of a revolution in connected cars. Our mission here at Microsoft Licensing is to push the boundaries of how our technologies can innovate, empower, and redefine connected cars. By the year 2020, there will be 250 million connected cars on our highways. So the real question is, where can we go next?
In fact, as a company, we're partnering with automakers in this nation and around the world, whether it's Toyota or Renault Nissan. As we look to the future, it's clear that the number of shipments every year of cars that are connected navigationally, connected to the internet, connected in terms of new forms of multimedia, are going to continue to grow. And ultimately, we're going to, quite obviously, see cars that can drive themselves. All of that involves technology. All of it involves hardware. All of it involves software, and all of it involves intellectual property and the licensing of patents to put automakers in a position to put this kind of technology to work. And so part of what we need to do to build a responsible cloud that really advances innovation is to think anew about how we advance the business of licensing patents together with the rest of the technology involved. Finally, I want to turn to the last issue, an issue that involves policy and law in multifaceted ways. It's this question of inclusion. How do we move technology forward without leaving people behind? I might suggest that this is perhaps one of the important issues of 2016 and one of the important issues of our time. Not just in the United States, but in the United Kingdom, in countries across Europe, in Asia, where people have been feeling challenged with widening gaps between the people who are benefiting and the people who are not. And it poses a number of questions and challenges for us all. Certainly, we think as a company about how we support businesses of every size. This should not and cannot be a technological era that helps only those companies that are large, only those companies in wealthy countries, only those companies that are older. We need to reach companies of all ages and sizes. We need to reach people, not just people in urban areas, but people in rural communities as well. And we need to think about what that means. In an era of cloud computing, people are able to use this technology to build their business, to connect with their families, to support their lives, to learn in schools, only if they have broadband access to the internet in the first place. And yet here in Wisconsin, the state itself has called out that it is a place of uneven broadband penetration. In fact, if you look at this map, you will see in the dark-colored areas very high-speed wireless LTE-based access. And you will see in those counties that are in white, people who live in communities that really do not have high-speed wireless access at all, under any definition. That has huge implications. At a time when the public is about to talk about the future of infrastructure, it's important to talk not only about critical issues like roads and bridges, but also the internet itself as a fundamental piece of infrastructure for this state and the entire nation. It calls on all of us, I think, to reflect on something more fundamental still. Over the last quarter of a century, we've seen across this country ongoing steady growth in the creation of jobs for people that have a four-year college degree. You see on this slide that since 1989, the number of Americans who have a four-year degree who have a job more than double. And what's interesting is that except for the recession, you see that we live in a country that basically generates those new jobs at almost the same rate, regardless of what party is in the White House or in Congress. But you see these other lines somewhat different. The middle line is for the jobs that are created at the rate of growth for middle-skilled jobs, those that involve people with a community college degree or similar certificate. But what really jumps out on this slide is the third curve on the bottom. This is the number of jobs in the United States held by people who have a high school diploma or less. And during a 27-year period when we've seen the number of jobs more than double for those with a college degree, the number of jobs held by that group has actually fallen by 13%. There are 7.3 million fewer jobs in America today than there were in 1989 for people with only that level of education. What does this mean? In a time where change in technology is one of the inexorable forces of our lives. What does it mean for businesses? It means, I think, as most of us in business recognize, that you can only be a healthy business if you are a learning business, where you are investing in the training of your own employees. What it means for an economy, especially a digital economy, is that we have to be a learning economy and pursue that as a nation. It means that we have to think about the next generation of people and the skills that they will need to succeed. We need perhaps to start by recognizing that as a nation today, we have 600,000 computing jobs that are open. And yet last year, as a country, we only produced 40,000 new four-year computer science degrees. What holds true for the nation holds true for Wisconsin. In a state that has 7,699 open computing jobs, all of the great colleges in this state and universities in this state put together last year produced only 890 of these computer science degrees. That's a huge gap. But it's not a gap that starts when we look at colleges. It's a gap that starts earlier in life. If you look at the country, what you will see is that we have 37,000 high schools in the nation, but last year, the number that offered the advanced placement course in computer science was only 4,310. Only 12% of the nation's high schools offered a course that I would argue is fundamental to the future of our kids. In Wisconsin, it's the same story. With 500 high schools in the state, with one of the great public education systems in the country, in my view, you had to be one of the fortunate few to attend one of the high schools where you could actually take that advanced placement course. And yet, when we're not yet catching up with the job demands of today, the reality is that jobs are changing. We're seeing new ways of working, new technology. We're seeing people much more frequently pursue multiple jobs and multiple careers over their lives. We're seeing people work independently, whether on a part-time basis or for an economic intermediary or even in the so-called gig economy for companies like Uber and Lyft and Handy. And at the same time, not surprisingly, the jobs are changing, people's needs are changing as well. They need the technical skills for tomorrow, but what we're also learning in study after study is that soft skills are as important as hard skills. Perhaps the most important skill is the ability to keep learning over the course of one's professional life. We need to step back and ask ourselves as a country, what will it take to create the workforce of tomorrow in ways that will foster opportunity for everyone? Again, I think it takes a shared responsibility. Employers will have new responsibilities to provide learning for their employees. Educational institutions will need to adapt. Those of us who create technology tools have great opportunities ahead of us. The public sector, by definition, given the nature of education, has a critical role to play. And guess what? All of us, as employees and individuals, will have to do our part. At the end of the day, despite all of the innovations and studies I've ever seen, I've never seen anybody suggest that you can actually learn without working at it. You have to spend the time to learn new things. Now, the good news is there's some clear opportunities ahead. There are new roles with heightened importance for higher education. And as we think about this, we need to think about what it will take to promote greater post-secondary education completion. We have so many opportunities in state after state around the country to better align the needs of the labor market with the courses and degrees that are coming out of our colleges and universities, not just at the four-year level, but at the community college as well. We have so many opportunities to innovate with more agile delivery for certificates and training. And of course, there is so much more work to do, not just to focus on the question of affordability, but how do we do a better job of helping students who start college actually finish it? Because there's one thing worse than graduating with a lot of debt. It's dropping out with a lot of debt. And too often, that is the reality in this country's community colleges and four-year institutions. We're then going to have to think about new models to connect workers with skills. There is a lot that one can learn from the rest of the world. And sometimes we live in a country where that's really not the first thing we try to do. When we do that, we frankly forget that American public education was really founded in 1835 in Massachusetts when Horace Mann brought to Massachusetts ideas that he had studied in Germany. And today, when we look at examples like the apprenticeship model in Switzerland, there are very interesting things for us to consider. We have so many opportunities to innovate with higher quality, minimal time, and lower cost education and training programs. And for those of us who are lawyers, there is a lot of work ahead of us. There's a lot of work to align labor laws with a changing workforce. The country's labor laws, I would argue, are very much a product of the 20th century economy. Under federal labor law, every person who works is one of two things, either an employee or an independent contractor. And yet when you look at the people who are working for companies like Uber and Lyft, it becomes increasingly difficult to conclude that they fit into either one of those two categories very well. And so therefore, people are starting to suggest that our labor laws need to evolve. We should have new independent worker classifications that will better encourage innovation by employers and protection for employees. And as we do that, as people work in these variety of different situations, there's opportunities to think about new models for worker benefits as well. More portable benefit models that can be taken with people, especially if they're working for multiple entities at the same time. And there's so much opportunity for experimentation in the private sector and among state and local government. As we do all that, there's a last couple of things for us to consider as well. As we think about a world where technology is ubiquitous, we constantly need to keep in mind, I believe, the need to ensure that technology addresses the needs of people with disabilities. The reality is that there are 1.2 billion people on this planet that have some kind of disability. That's why we're seeing more laws and regulations around the world. That's why we're seeing more focus, rightly so, at technology companies like Microsoft, so that we do a better job of developing technology that can be used by people who may be blind or visually impaired, that may have other physical disabilities, that may have cognitive challenges. We have to recognize that technology can make or break their ability to be successful in the workforce. And then there's a last thing I think we should consider as well. In a sense, it's perhaps one of the greatest challenges as we look around the country and around the world. It doesn't necessarily involve law. It doesn't necessarily involve policy. In fact, it doesn't necessarily involve the government all the time. But it involves the opportunity for us to create technology that enables us to forge better connections between people. We live in a world that is changing so quickly. We live in a world that is so diverse. We need to think about and find new ways to use technology that helps people better understand and learn about other people. People in other countries, people halfway around the world, or sometimes people across the state. That's why of all of the things that inspire me and inspire us, sometimes we're the most inspired by what we see people using technology to do in ways that advance human understanding. It's why we're inspired not just by what we see where we're headquartered in Seattle. It's why we're inspired by what a teacher has done in a small town in Wisconsin, south of Madison, a story that you see here.
Of the tools that I can use to empower my students to impact the world, but more importantly also for them to be impacted by the world. And so I look at tools like Skype or like Twitter or any of the communication tools that are out there.
Most teachers up until now, like, get off your phone, stop using social media. Kids don't really know all the things you can do with technology, and I feel like if teachers showed that to them, they would start using it in positive ways.
We talk a lot about in 7th grade English how at the end of the year, it's really about becoming a better human being. And so we started a project, and then I just said, what should America's role be in the refugee crisis? And I was helping a child, and another kid says, wait, I don't even know what refugee means. And another child at the table said, oh, it means the enemy. As we kind of explored, the kids started having all of these questions. So I sent a tweet out and I just said, would anyone want to Skype with my kids? I'm connected to an incredible educator up in Toronto. And she said, yes, I'll share my story with you. And it was incredible to see the kids crowded around the computer. Bert immediately came to mind because during the Skype call with Rasul, he kind of hesitated. I could tell he had a question, and finally he got the mic.
I asked her about how people would treat her when they saw that she had a scarf over her head and if it would alter the way that they talked to her or anything. She said it did, but she learned to kind of ignore it and live but not let it affect her, so that was really cool to hear that.
You could just see that all of a sudden things clicked into place that hadn't clicked into place before.
I have been bullied, and I know what it feels like to be judged, like right when you walk in a room, and I just wanted to see her side of that. Like maybe she would give me a different opinion so I could like work past it. So that was really cool to hear that.
I look at my kids and I take that responsibility, very much to heart. This is the future. And if we don't teach them more empathy, more kindness, then what's our future going to look like? And so for me, the fact that we now have this incredible accessibility to technology tools that can bring the world in and create shared experiences with kids around the world or adults around the world, it means that the kids are leaving this little classroom in Oregon, Wisconsin, understanding that they're part of the global world. And that's so important.
So I would say, regardless of whether we are Republicans or Democrats, supported Hillary Clinton or Donald Trump, regardless of whether we believe that the country should build a wall or construct a bridge, there is an opportunity for us to use technology in ways that help people learn more about the world in which we live. We live in a world where the American people represent only 4.5% of the global population. Our future depends on understanding the rest of the world. In fact, we live on a pretty small planet. But I do believe that with the right kind of thought and discussion and innovation in the law, and with better use of technology, we can ensure that this isn't just a small planet, but a better world. Thank you very much.
Thank you. We have time for a number of questions, and so what I would propose to do is, if you have a question, if you can raise your hand, and I will recognize you, and then I believe Ryan will get a microphone over to you. So, questions? Yes, first here. No, go ahead. You're on.
Can you
Technology.
Can you just can you talk about the tension that you feel or that you've seen within the law in terms of transparency versus privacy, and how that how you see that going forward?
Well, it's a great question, and I think there's a healthy tension in the law between, call it, public safety and transparency. And then we need to think about whether we can balance that tension in a way that I would say sustains a healthy outcome. Where the rubber meets the road, in my opinion, is the First and Fourth Amendment rights that we have as a technology company to share information, and the rights that we have as people to know when the government is accessing our information. And then you see that implemented in specific statutes. We're in court litigating over a specific statutory provision in the Electronic Communications Privacy Act that was passed in 1986. And the basic question before the federal court in Seattle is, when should a search warrant to obtain someone's email remain secret? And for how long should it remain secret? And what is the showing that the government should have to make for it to be a secret? And what you have is a 1986 statute that was not written with all of the anticipation of the technology that we have today. So we would argue in the first instance that, of course, things should be secret if it could put someone's life or property at risk, if it could lead to the destruction of evidence, if it could unreasonably thwart the government's ability to investigate and prosecute a crime. But we also believe that when the government goes in and gets such a search warrant, it should have to make a real showing that that is the case. And in fact, as we reviewed what were literally the 3,000 or so search warrants that had been served on us, we came to a conclusion that these kinds of secrecy orders had just become too routine. And in fact, in the court in Seattle, we have literally 20 years of former United States attorneys and the former head of the Seattle FBI office all filing an amicus brief together, saying that that is their view as well. What we do think it makes more sense to do is have a bit of an elevated showing, to then give the government, say, something like 90 days to keep it secret. And if the government finds, as the 90-day end approaches, yet it still needs secrecy, it can go back and ask for an extension of time. But eventually the secrecy will expire. Something like that we think would be a much more sensible approach than what we have now.
We had a question over here. Yes. Can you press the rim of the microphone? Thank you. And hold it down as you ask the question.
Sure. I have two questions. How do lawyers within your in-house law department practice continuous learning? And how can law schools implement new curriculums to teach law students the philosophy of continuous learning outside just learning about case law?
Well, within our legal department, we have 540 lawyers. Basically, 300, it's actually 299 are in the United States, and the remainder are in 54 other countries. And, so as you can imagine, if you're a lawyer at Microsoft, I mean, things are constantly changing. So, one of the ways that we constantly get smarter is we rely on lots of outside law firms to keep us up to date with changes. So that's a ready vehicle that those of us who are inside a company can use. We invest quite a bit of energy in ongoing learning and development tools and programs. We have people come in, and then we encourage people to get out and go to continuing legal education programs, to participate in discussions. Frankly, it's our goal not just to ensure that we're keeping up with the law, but to be part of the conversations that are changing the law. And so we try to get out and participate in these conversations themselves. Now, when you get to the question of how can law schools do the best thing, the first thing I would say is I am sure, knows a lot more than me about the right way to do that. But I would say, three things. I mean, one is obviously the curriculum needs to evolve, and it is. I mean, if you look at the curriculum today that students have, it's very different from, say, the curriculum that I pursued in the early 1980s at Columbia Law School. So, the fields are changing, and I think law schools are keeping up with that. Second, I do think there's lots of interesting questions for legal education in America. What's the best way to use the third year of law school? What more forms of practical training can we provide? And I do think that, adjunct professors and seminars and clinics and other things are hugely important. And then the third thing, frankly, is bringing in people to expose students. I'm sure somebody thought of that when this lecture series was created, so that law schools are connected with what's going on across the country and around the world. I'm generally, reasonably upbeat about where law school education is going. I do think that there's an ongoing opportunity to innovate with the third year of legal education. And I will say nationally, one of the things I love about Wisconsin is it's had the good sense to say that if you can graduate from Marquette Law School and you want to practice law in Wisconsin, you don't have to take the bar exam. And I wish other states would follow that, including Washington. Let's let people use their time to learn new things and not just show that what they learned 3 years ago is still in their head in some relatively arcane way.
I think we have time for another question or two. Yes.
You talked about the search warrant litigation, and there is currently a movement afoot at the CFTC to undermine the protection of the subpoena powers with respect to source code, and wondered if you could comment on that from your perspective.
Yeah, I mean, I will first tell you I have not followed the case at the CFTC as closely as I've followed some other cases, but mostly I believe that the government has many ways to access information today. When I testified before that House Judiciary Committee, the person who was on the panel next to me was Michael Chertoff, who was the Secretary of Homeland Security under President George W. Bush. And there was this question about whether government had more power or government had less power in the world of technology today. And he actually said, look, I think government has as much or more power to go get information and evidence than it has had in the past, in part because so much is stored digitally. So mostly I fall into the camp of saying, I want to make sure that the rights of individuals and companies continues to be protected, especially since I do think on balance that the pendulum swung quite far after 9/11. And I also say this as somebody who is very cognizant of the importance of public safety. I'm not inclined to make broad, sweeping statements that have no qualification whatsoever, because there are horrendous fact patterns that one can imagine. But I do think that there is plenty of room for balance in a way that basically continues to uphold the rights of individuals to know, and the rights of individuals, and for that matter, companies, to defend themselves, in these kinds of situations.
I think we have time for one more question. Yes, in the far back.
I was wondering, how do you see artificial intelligence and machine learning affecting the legal profession?
Great question. And there's a big debate, or if there's not a big debate yet, there will be a big debate in the future. The real question is, will artificial intelligence replace certain tasks that lawyers perform? Well, let me first say, before one answers that question, I think there's a bigger opportunity for artificial intelligence. One of the fascinating things about the legal profession, to me, is the permanent gap between demand and supply, certainly in a country like the United States. You literally see hundreds of thousands, if not millions of people every year who would benefit from legal service who cannot afford to pay for a lawyer. And as somebody who has been very involved in the pro bono legal community, as enthusiastic as I am about pro bono support, I don't believe that pro bono services will ever fill that gap. Nor do I believe that the cost of legal services will, or frankly, perhaps even should, fall to a level that would fill the gap. But I do think artificial intelligence can help. If you just think about a lot of tasks that are performed, that, for, say, people of lesser means, including in a pro bono environment, you need to interview somebody. They need to provide information. You need to do case intake. I believe that, in 5 years, there are many scenarios where that initial work can be done by a computer that can interview somebody in a lot more friendly way and gather their information. I believe that there's a lot of artificial intelligence that can be put to work to help people navigate the law in different states. We've provided $1 million grant to a group called Pro Bono Net and the Legal Services Corporation to innovate in that space. So first and foremost, I hope that artificial intelligence can be put to work there. Now, will there be other areas where artificial intelligence will change certain tasks that are done by human beings that have a law degree? Yes. That's been happening actually since I graduated from law school in the 1980s. My first job as an associate in Washington, D.C. was literally to spend many weeks in a file room with a tape recorder dictating summaries of 110,000 pages of documents. By the time I reached page 10,000, I seriously questioned why I had gone to law school in the first place. Young associates don't do that today. All these documents are stored digitally and people rely on search technology. So there will be certain basic tasks that probably will be automated. I don't believe, though, that that will for a moment replace the most important things that lawyers do. That creativity, that judgment, all of those soft skills that are so important to what people need to accomplish in the world. Whether it's deciding what to do with their inheritance, or deciding whether to bring a lawsuit, or how to close a deal. Lawyers, I think, have these tasks as human beings, these abilities as human beings that computers can complement. But I will say, certainly in all of our lifetime, and probably the lifetime of the generation that will be born in the next decade, I don't see that being replaced by artificial intelligence.
Thank you. I want to do 3 things as we conclude here. First, I want to thank Brad Smith for really a terrific Nies lecture. It was billed as from Wisconsin to the world, and truly, both from a global perspective and in terms of things here in Wisconsin, we are very grateful for your lecture. Second, I want to say that yes, thank you. Second, I want to say that we will have a very informal reception, as we always do, out in the Zilber Forum. I know that at the risk of using a cliche, Mr. Smith is going to Washington very soon, but he will be out in the Zilber Forum for a little bit. And then the third and final thing falls in the category of personal privilege. Mike Goucher covered half of it this afternoon when it was disclosed, of course, that as one would expect of someone who grew up in Appleton, Wisconsin, Brad Smith is a Green Bay Packers fan. Some of you will recall the Nies lecture last academic year when my good friend Ted Elliott decided for his opening gambit that he would disclose to the world at large that I'm a Minnesota Vikings fan. And so when you brought the world together at the end, whether it was Hillary supporters or Donald supporters, people who favored a wall or favor a bridge, we can even bring together the Packers and the Vikings. Thank you.
Absolutely. Thank you. Thank you.